right, with the two members sitting down, we are quorate. Just. Might have been a short afternoon otherwise, but... Before the luncheon adjournment, indeed at the beginning of the sitting this morning, Deputy Wilson asked me to review the contents of the answer provided to written question 403. That question was addressed to the Minister for Sustainable Economic Development, and insofar as is relevant, it reads, in relation to the island's ferry tender process, will the Minister advise? And then there are a number of sub-paragraphs. E says the total expenditure on the tender process, including contingencies, and how value for money has been demonstrated. The answer is provided in the same lettered paragraphs, and in the answer to E, although there is a description of certain aspects of the tender process, there is no reference to sums involved, including contingencies or otherwise. It seems to me that if those figures are available, and if there is no reason why they cannot be provided, then the question at E certainly asks for them in requiring total expenditure. If there is a reason why they cannot be provided or they are simply not available, then the answer should explain what that reason is and that it's not available. So in my view, answer to section E does not meet with standing orders, and I direct that the Minister provide a revised answer to that part by 9 a.m. tomorrow morning. Very well, we now move on with public business. The first item is the draft Family Division Registrar change of status entitled Jersey Law P.56, lodged by the Minister for Justice and Home Affairs. The main responder is the chair of the Children, Education and Home Affairs Scrutiny Panel, and I ask the greffier to read the citation.
Draft Family Division Registrar change of status and title, Jersey Law 2000, a law to change the status and title of the Registrar of the Family Division of the Royal Court and for connected purposes. The States, subject to the sanction of His Most Excellent Majesty and Council, have adopted the following law.
Minister.
Thank you, sir. I'm bringing this draft amending legislation forward to rectify what senior members of the Island Judiciary and other legal representatives have for a long time seen an inaccuracy in the status and title of registrars in the Family Division of the Royal Court. Currently, registrars are officers of the Judicial Greffe, but in reality they are family judges in the Family Division of the Royal Court, who are accepted as being members of the judiciary within the courts of Jersey. The primary role of a family judge involves the exercise of judicial determination, the issuance of judgments and associated acts of court, determining rights between litigating parties, with those determinations being open to appeal before the Royal Court for family division related issues. In this regard, the function of the family judge is akin to the roles carried out by other members of the Jersey's judiciary. Classification as a member of the judiciary effectively safeguards the independence of these roles and maintains a separation of powers between the judiciary, the executive and the legislature, and is where the role of family law should lie. Sir, it is imperative that the legislation and working structures relating to family judges reflect both the appropriate employment classification and reporting structures. We are lucky at the moment as we have two highly qualified and respected individuals who function as family judges, but we cannot afford to rest on our laurels. I am aware that the complexity and number of cases which the family judges deal with continues to grow. We need to ensure that we are able to retain existing staff and attract highly qualified, skilled individuals in the future who have the required qualifications and experience. The amendments I am proposing today will make the role of family judge more attractive whilst also reflecting the important work a family judge undertakes. In summary, this legislation amends the Royal Court Jersey Law 1948 and formally establishes the office of family judge within the Royal Court and amends the status and title of Registrar to formally become a family judge as a member of the judiciary. I'm grateful, sir, to the Children's Education and Home Affairs Scrutiny Panel for their comments paper and for them having taken the time to be briefed on this matter. Sir, I move the principles.
Are the principles seconded? Yes, sir. Does any member wish to speak on the principles? No member wishes to speak on the principles. When I close the debate, those in favour of adopting the principles kindly show. Those against? The principles are adopted. Does the Children Education Home Affairs Scrutiny Panel wish to scrutinise the matter, Deputy Curtis? How do you wish to deal with the matter in second reading, Minister?
Sir, I would like to take the articles in the legislation as one. If the Assembly is happy with this, I will continue. The effect of this amending legislation is twofold. Firstly, in order to recognise the judicial nature of the role and the responsibilities a registrar carries out on a daily basis, this draft legislation formally amends the title of registrar to family judge and alters the status of the person to that role from being a member of the judicial greffe to that of a family judge appointed by the bailiff. Secondly, it establishes the office of family judge in the Royal Court in respect of the family division and formally allocates to the family judge the judicial functions previously delegated to the registrar by the judicial greffe. Sir, if I may give a little more detail, registrars now function as family judges mainly under powers delegated to them from the judicial greffe. The initial legislative functions and responsibilities allocated to registrars were set out in the matrimonial causes, Jersey Law 1949. Sir, under the law, registrars had responsibility for the authentication of decrees, orders and other instruments in relation to matrimonial matters. Although a registrar still performs these duties, their responsibilities have expanded both in number and complexity considerably since the commencement of the 1949 law, and even more so as the Royal Court continues to allocate them more wider responsibilities. The remit of a registrar for family-related matters now incorporates similar responsibilities as are expected from other judges in Jersey's Royal Court. Sir, in order to safeguard both the independence of the role of family judge and the judiciary of this legislative proposes a change to the employment status of a family judge from an employee of the State's Employment Board to a member of the island's judiciary with future appointments overseen by the bailiff. This approach brings the employment status of a family judge into line with other similar judicial appointments. The draft law specifies that the bailiff is responsible for the appointment of family judges and sets the minimum qualifications required to be held by a person appointed as a family judge. The appointment process followed will largely be in line with that followed by the appointment for a commissioner of the Royal Court and the magistrate. Sir, I'm aware that we need to retain the independence of the judiciary whilst also ensuring that there are the correct governance arrangements in place to cover the appointment processes for members of the judiciary. I'm conscious that these proposals do not include any statutory provisions which govern how these appointment processes will be administered. That said, the bailiff does follow set processes for judicial appointments. The need to uphold the independence of the judiciary and improved governance surrounding appointments was highlighted in the consultation. Judicial independence and the establishment of a Judicial and Legal Services Commission. To ensure consistency, any statutory amendments to the appointment processes for members of the judiciary will be addressed as a whole and are outside the scope of the issue I have brought for you today. To ensure uniformity across judicial salaries and that remuneration is proportionate to the demands of the role, the salary of a family judge will be determined by the State's Employment Board following consultation with the bailiff and negotiation with the post holder. Importantly, this draft legislation provides that any person who is currently in post as a registrar immediately before this law comes into force automatically becomes a family judge on its commencement. Any newly appointed family judge will be required to swear on oath. The oath, as detailed in the legislation, is similar to that sworn by a newly appointed commissioner. Sir, I am proposing consequential amendments to other pieces of state's legislation in order to recognise the judicial nature of the role of the family judge and to remove those functions which the judicial greffier previously delegated to the registrar and impose those functions on the family judge. Rules of court will also need to be appropriately updated. There are also a number of housekeeping amendments which assist in recognising the judicial nature of the role of family judge and help maintain the actual and perceived independence of the judiciary. These include those which enable family judges to be members of the Public Employees Pension Scheme. In conclusion, sir, this draft legislation proposes amendments to the status and title of those who carry out the important functions of a registrar of the family division and formally recognise them as a family judge. We need to ensure that our legislation enables our judiciary to retain and recruit suitably qualified and experienced people. I believe that the changes in this draft legislation will help to achieve this. So I commend this draft legislation to the Assembly and ask States members to support my proposals.
Are the articles seconded?
Yes, sir.
Any member wish to speak on the articles? No member wishes to speak, then I close the debate. Those in favour of adopting the articles kindly show.
May I have the appel, please, sir?
The appel is called for. I invite members to return to their seats. The vote is on the articles, and I ask the greffier to open the voting. If members have had the opportunity of casting their vote, then I ask the greffier to close the voting. The articles have been adopted in second reading. 37 votes pour, no votes contre, no abstentions. You propose in third reading, Minister?
I do, sir.
Is it seconded for third reading?
Yes, sir.
Does any member wish to speak in third reading? Deputy Joseph.
Thank you, sir. I wonder whether the Minister, in highlighting the importance of judicial independence and the proper processes that are no doubt informally may be in force, I would ask, I know that a previous Constitutional Review subcommittee spoke of the importance of a Judicial Appointments Commission, and I wondered whether or not the Minister was going to give this any consideration in the forthcoming time, as it is a standard which is adhered to by the Latimer House Principles, of which is proudly wearing a Commonwealth Parliamentary Association badge, which is a default position for the Commonwealth.
There's no doubt about it. I'm sure, Deputy, that is an appropriate question in many circumstances, but debate on third reading has to be the adoption or otherwise of the law as passed in second reading. It can't go wider than that.
I should have made the speech earlier.
Does any other member wish to speak? No other member wish to speak. As that wasn't a speech, I close the debate and put it to the vote. All those in favour of adopting in third reading kindly show. That is called for. I invite members to return to their seats. I'll ask the greffier to open the voting and members to vote. Members have had the opportunity of casting their vote. I ask the greffier to close the voting. And the law is adopted in third reading. 40 votes pour, no votes contre, no abstentions. A P.66 has been deferred because the Minister is not available. So we move now to the draft Royal Court and Stamp Duties and Fees Jersey Amendment Law, P.67, lodged by the Minister for Treasury and Resources. The main responder is the Chair of the Corporate Services Scrutiny Panel. I ask the greffier to read the citation.
Draft Royal Court and Stamp Duties and Fees Jersey Amendment Law 2000, a law to amend the Royal Court Jersey Law 1948 to make new provisions for the remuneration and expenses of jurats, and the Stamp Duties and Fees Jersey Law 1998 to increase court fees and to make other amendments to that law. The States, subject to the sanction of His Most Excellent Majesty and Council, have adopted the following law.
Minister.
Thank you, sir. I'm going to propose the law as amended.
Oh, yes, I beg
Sorry,
your
there's
pardon. Well, I think we do that in second reading because it's an amendment to one of the specific articles. So I think you propose the principles. By all means, indicate whether you accept the amendment as you go, but we won't actually put it. There's no reason to put it as
Okay.
amended.
Apologies, sir. Sir, I am pleased to propose this draft law as amended, and if it is passed, then it will achieve several key objectives. Firstly, the law abolishes jurat stamps, which are the last remaining physical excise stamps, by repealing the related 1938 law from an appointed day. Since 1938, the sale of these stamps has funded the honoraria of our jurats. Upon the law's enactment, stamp sales will cease as soon as relevant departments have updated their computer systems to collect the uprated fees. In future, the Treasury will fund the annual honoraria for jurats through the regular annual budgeting process. I have committed initially to setting aside £65,000 annually, which would be distributed among the jurats by the bailiff according to various criteria relating to their service. This sum is greater than the revenues currently arising from the sale of jurat stamps, and in my view represents good value for the taxpayer. Jersey greatly benefits from the dedication and indeed hard work of our jurats, and this change provides a more appropriate level of remuneration, albeit still very small, for the work they do. Secondly, the draft law adjusts judicial fees for matrimonial proceedings and probate fees, aligning them with inflation. This specifically affects the so-called lettered rates, which are defined and used in the three schedules of the 1998 Stamp Duties and Fees Law. Thirdly, a new lettered rate, the Q rate, of £5,000 is introduced into the 1998 law, reflecting the costs involved to the judicial system of more complex cases for proceedings involving costs exceeding £10 million. The draft law makes most judicial fees in Schedule 1 of the 1998 law non-refundable, recognising that the bulk of the costs of to the judicial system are incurred even if cases are settled late, thus avoiding a final hearing. However, the designated officer, who will be the judicial greffier in most cases, or sometimes the bailiff or viscount, will retain discretion to make refunds in appropriate circumstances. Sir, additionally, I would point to the following changes in the draft law. For now, we need to keep the references to stamp in the 1998 law, even though physical stamps will no longer exist. We're updating the definition of stamp in the 1998 law to reflect this, and government receipts for payments will serve as evidence of fee payment going forward. I emphasise that this change does not affect the two stamp duties in the 1998 law, which are effectively taxes, namely duties on mortgages and freehold land transactions. No changes are made in respect of these, and they continue to be addressed through the annual budget and finance law procedures. Sir, this legislation marks a significant step forward in modernising the administration of our judicial processes, and I commend it to the Assembly. Thank you.
Are the principles seconded? Yes. Does any member wish to speak on the principles? If no member wishes to speak on the...
I wonder if I could have your guidance as to whether it's appropriate to speak on my amendment at this stage on the principles of the bill or when we come to the articles. But when we come to the articles, the article about which I wish to speak won't actually be there because it's not going to be proposed, and I don't wish to be ruled out of order.
Well, I mean, It seems to me the Minister has indicated she's accepting the amendment, and therefore you're right, the article won't be proposed. I think if you wish to make some reference to it, Deputy Bailiff, now is probably the appropriate time.
Thank you, sir. It's worth making the point, sir, I think, because the amendment raises an important point of principle, which is the extent to which matters should be delegated to the executive, to the government, by this assembly. All governments, sir, like to accumulate power. Sometimes it's right that functions should be transferred from the states to ministers. If it's more convenient, for example, or if it's a minor administrative task which should be more effectively undertaken by a department or by the executive. But sometimes it's not right. And so I made the point in relation, no, I made the point, this very point actually, recently in another debate in relation to the approval or ratification of treaties entered by the executive. The Minister was not present when I made the speech, but I hope its content will have been relayed to him. And we will perhaps have the opportunity to talk about that on another occasion. But in this case, it seems to me that decisions as to how much citizens should have to pay in order to access justice, in order to bring proceedings in the Royal Court or in the Magistrates' Court, should not be left to one individual, that is to say, a minister, however reliable the present incumbent might be. As a matter of principle, such matters should be decided by the states. And so I'm grateful to the Minister for her decision to accept my amendment, and I shall be supporting the articles when they are moved, minus the article which is not to be proposed.
Very much. Does any other member wish to speak on the principles? Deputy Joseph.
Thank you, sir. Just following Deputy Balash's intervention about the articles that are not there, I wonder when the Minister sums up, she could actually take the opportunity of explaining why, on this occasion, the Executive sought to take this power, because it appears that Deputy Balash was absolutely right, and this is a good opportunity to explain why they did it and why they changed their mind, if I may politely ask.
Does any other member wish to speak on the principles? No other member wishes to speak? Then I close the debate and call upon the Minister to respond.
Thank you, sir. I thank the Deputy for his amendment, which, as I said, I will be accepting, and to reflect both Deputy Pash and Deputy Joseph's comments. As Treasury Minister, I'm always mindful of the costs associated with achieving state's business, and it's a guiding principle across legislatures that, where practical, business should be conducted in a cost-effective and timely manner, subject, of course, to ensuring proper scrutiny by the elected legislature. As a general rule, primary legislation is more expensive than regulations, and regulations are more costly than orders. That's one of the reasons why I supported the principle to allow for order-making powers to amend the lettered rates set out under specific schedules in the stamp duties law. Order-making powers allow for the Minister to amend certain sections of legislation in an efficient and cost-effective manner. Order-making powers can still be challenged under Standing Order 26(3)E, which requires a 2-week lodging period for a proposition to annul them. This ensures that a check and balance remains with states members. My initial proposal for an order-making power was made with the intention of enabling more regular and timely reviews and possible adjustments to court fees. In the present case, the initial approach of the proposition would have helped us avoid the situation we face today with P67, where I am asking members to approve a substantial increase in fees. The Schedule 1 fees were last uprated in 2022, while those in Schedule 2 and 3 were last revised in 2018. So there were other reasons for another good reason for the order-making power was to reflect that the departments involved and the officers involved are non-ministerial departments. So your own chamber, sir, the Viscount's department and the Judicial Greffe are non-ministerial. They often find it difficult to find ministers to bring forward propositions for them and to gain time within the legislative timetable. And indeed, this whole proposal has been slightly delayed while we worked through who was going to support the proposition. I would say that I don't necessarily agree with Deputy Bailiff that there is an access to justice point. I think it would be very unlikely that a minister would increase fees to such a level that people were excluded from the courts. And I can't believe any minister rationally seeking to do that. I would also just remind the Assembly that Article 7 of the Stamp Duties Law, particularly bearing in mind access to justice, gives the Viscount a power to exempt a person who wishes to bring court proceedings from judicial fees subject to terms and conditions. That is a provision that the legal profession are very, very familiar with. And when I was Viscount, we regularly and frequently received requests for exemptions from fees. They were always granted in family proceedings, particularly those involving children or family matters, and they're also available in civil law matters where the Viscount considered that there was a reasonable case with merit. So judicial fees and court fees, the existence of those are not a barrier. There is no barrier because the Viscount has the power to grant people exemption from fees, normally on the basis that if they recover an adequate award, the fees will be paid at a later date. So I wasn't intending to go into all of that, but I just did feel I wanted to touch, as a lawyer myself, touch on the access to justice point. But as I say, I accept the amendment, and we just have to now make sure that we do have try to get a more regular approach, because it's not helpful to do big amendments. I would have thought it's better for people to do more regular, smaller increases than to do 5 yearly amendments that are significant. So that's my rationale. Thank you, sir.
Very well. Those in favour of adopting the principles kindly show.
Can I have the appel, please, sir?
As called for. Invite members to return to their seats. The vote is on the principles. And I ask the greffier to open the voting. Members have had the opportunity of casting their vote. I ask the greffier to close the voting. The principles have been adopted. 42 votes pour, no votes contre, no abstentions. You've already indicated, Minister, I think that you accept Deputy Balash's amendment.
Yes, sir.
Are members content to take the articles as amended? Very well. In which case, how do you propose in second reading, Minister?
On block, please, sir.
Are they seconded for second reading? Does any member wish to speak in second reading? Deputy Oates.
Can I say to the Minister, I hope this is not going to be out of order, because it's out of order because she struck out what she said, but she gave an absolutely exemplary explanation from her experiences, no doubt, of Viscount, of why actually this Assembly's time should be taken with things. And I compliment her for that. And I'm somehow doubting why I'm now being asked to support something which she gave such a compelling reason to actually maintain by order. I will support her, sir.
Very well. Does any other member wish to speak? No other member wishes to speak? I close the debate and call upon the Minister to respond. Sorry, before you do, I'm sorry, just to interrupt. I forgot to ask the scrutiny panel whether they wish to call the matter in. Deputy Miles, I do apologise.
No, thank you, sir.
Oh, there, I wasn't expecting to, but thank you. Sorry, please do respond.
So I'm grateful for the Deputy's comments, but I think I've now already committed myself. Thank you.
Very well. Those in favour of adopting in second reading kindly show.
Have the appel, please, sir.
The appel is called for. I invite members to return to their seat and the referee to open the voting. Members have had the opportunity of casting their vote. And I ask the greffier to close the voting. The law is adopted in second reading, 42 votes for, no votes contra, no abstention. Do you propose in third reading, Minister?
Yes, sir.
Is it seconded for third reading? Yes. Does any member wish to speak in third reading? Deputy Joseph.
Very briefly, sir, there's an expression, sir, called buttering up, and you're now approving this in the third reading. And I just wondered whether or not, in having got this approval through, whether the Minister is going to be so helpful in relation to other stamp duty amendments. I'm just making a very cheeky point, sir.
I'm sorry, was that an argument as to whether we should adopt this vote in
yes,
second reading?
Yes, it was a very definite argument in favour of an amended amendment on stamp duty,
sure it was, Deputy.
I think it was an amendment, sir, yes.
So, I'm not going to call upon you to answer that. Does any other member wish to speak? No other member wishes to speak, then I close the debate. Those in favour of adopting. Do you call for the appel, Deputy Doublé? I ask the greffier to open the voting. If members have had the opportunity of casting their vote, then I ask the greffier to close the voting. And the law is adopted in third reading, 42 votes for, no votes contra, no abstentions. The next item of public business, in fact the final item of public business other than the in-committee debate, is pets in rental properties, P.70, lodged by Deputy Catherine Curtis. The main responder is the Minister for Housing. There's an amendment lodged by Deputy War. Deputy Curtis, do you accept that amendment? No, sir. No, very well. Then we'll deal with that amendment separately. I'll ask the greffier to read the proposition.
The States are asked to decide whether they are of opinion to request the Minister for Housing to bring forward for approval before 31st of March 2025 any necessary legislative changes to ensure that any tenant of a rental property be permitted to keep or acquire a pet or pets unless the landlord of the property provides a reasonable reason for not permitting this, and for the criteria determining these reasons to be defined within the relevant legislation.
Yes, Deputy Curtis.
Thank you, sir. I expect that most states members will have pets. I'm sure that we can all appreciate the heartache and distress to ourselves, our families and our pets if we had to give them up. If for any reason we had to move house, we would not expect to have to give up our pets. Those of us here who run our own households and have pets expect to be able to keep them. As the saying goes, a dog is for life, not just for Christmas. If that's good enough for us, it's good enough for all. Most states members are fortunate enough to own their own homes. I'm lucky to have a long lease with a pet-loving landlady, but we are not all that lucky. Nearly 50% of Jersey's households are rentals. Around 1/3 are private rentals, and many of those are 1, 2 or 3 year leases. So moving house happens frequently in the lives of private renters. And those renters would most likely love to own their own homes, but either can't get together a deposit of tens of thousands of pounds or can't get a mortgage. It's not like in the past when people rented for a year or two while looking to buy their own place. Nowadays, many Jersey residents will spend a major part of their lives in rental properties. These are their homes. Can we really justify denying people the opportunity to own a pet for most or all of their lifetimes? Can we think it's okay for children to grow up without ever having a pet, or to have to give up a beloved family pet? I'll now give a few examples of how blanket bans on pets affects our island population. So firstly, a couple with 2 pet dogs whose home was destroyed by the tornado, they still don't have a home because they will not give up their dogs, and the houses they've seen which are suitable have a ban on pets. An older lady who had to give up her cat several years ago and still misses him. A family with 2 children in which the father died unexpectedly, who had to move to a cheaper house but were told they couldn't keep their dog. A care worker with a little dog who has to leave her home of many years at the end of her lease because it's been sold and she cannot find anywhere with outside space that will allow her dog. I hold weekly constituency meetings, and I've had many people call in to tell me about their difficulties with renting. And this issue of blanket bans on pets is causing a lot of distress. I'll now quote from the report to the proposition. In Jersey, it is estimated that approximately 1 cat per month is given up to the cat sanctuary due to accommodation restrictions. Data supplied by the JSPCA shows that 17 pets per year on average were disclaimed to the JSPCA due to the landlord specifically not allowing pets. Another 42 per year where the reason given for disclaiming was moving, and another 6 per year where the reason given for disclaiming was change in circumstances. The JSPCA also finds that not allowing pet ownership in accommodation affects their potential for rehoming a pet. As well as hearing from many tenants, I've heard from some landlords. I've had 3 landlords write to me who have blanket bans on pets because they've had bad experiences in the past. These seem to be good-hearted, responsible people, and I understand why they are wary. However, banning all pet-owning tenants is not the way to go. They have said to me that landlords should be able to do what they want with their properties, and I agree with them. But while landlords should have the right to do what they want with their properties, so should tenants be able to live the way that they want in their homes. As soon as a landlord agrees to a lease or any other contract with a tenant, there is a negotiation to those rights. All I'm trying to do is to stop blanket bans, so the landlord can still choose the tenant that they think suits the property best. The landlord can absolutely refuse pets if the property is not suitable. While drafting this proposition, I asked to meet with the Jersey Landlords Association to inform them and to get their feedback. We discussed the responsibilities of a landlord, and my understanding is that it is a huge responsibility to be a good landlord. My understanding also from our discussion was that good landlords consider each case on its merit and don't apply blanket bans. The JLA has since sent all states members a letter describing their concerns. I have to say I'm in agreement with the items they list as potential adequate protections for landlords. I think we're generally all in agreement here. The only contested point is whether it be in the form of guidance or legislation. Unfortunately, guidance will not be sufficient. Like every other group of people, landlords include good and bad. Guidance will have no impact on bad landlords. And what's under consideration here is the rights of people to live in their homes, the lives that they wish to live. So legislation is necessary. Sometimes pets cause damage to property. I expect we have heard, and probably will hear from some deputies in this debate, some of these horror stories. Fleas, destroyed carpets, mess. That's caused by just some bad tenants who don't take care of their pets. Perhaps they're overwhelmed, or perhaps they just don't care. Either way, it's a nightmare for the landlord. But there are ways for a landlord to seek recompense for any damage caused by a pet to the property. For instance, landlords could require a tenant to pay the landlord's reasonable costs towards maintaining insurance, or an additional pet deposit could be requested. That seems completely reasonable, and I understand that the Housing Minister would bring the details of the legislation back to the States Assembly for consideration. Letting out properties is a business, and anyone who's ever run a business knows that it's inevitable that there will be some bad customers. That doesn't mean it's okay to ban them all. Research conducted by Dogs Trust and Cats Protection reveals that in over a third of cases where cats or dogs have not been allowed by a private landlord, the landlord did not proactively decide this based on the individual tenants or pets, but either followed generic advice or used a standard tenancy template. The charity claims that allowing pets in rental properties is not just good for tenants, there are advantages to landlords too, as it could increase the length of time tenants choose to rent a property. The research shows that some 26% of tenants would stay longer in a property if they were allowed to keep a pet. Not that long ago, it was acceptable and legal for landlords to put blanket bans on children. Thankfully, those days are gone. Pets are part of the family, and all this proposition does is to remove blanket bans on pets. Landlords will still be able to choose their preferred tenant, will still be able to refuse pets for a valid reason, and will be enabled to claim higher funds from the tenant to put right any damage. Any one of us who cares about animals, and the men, women and children in those 50% of rented households in Jersey must support this proposition.
Is the proposition seconded? Yes, sir. There's an amendment to the proposition brought by Deputy Warren. I ask the greffier to read the amendment.
Page 2. Delete the words "for approval." Substitute the words "any necessary legislative changes to ensure" with the words "guidance to tenants and landlords so." After the words "permitted," insert the words "to request." Substitute the word "legislation" with the word "guidance."
Deputy.
Thank you, sir. I'm not sure we should declare an interest because I'm a landlord through my business, and I'm not sure if we need to make that declaration. I'll make that declaration anyway. Okay. Sir, I read the Housing Minister's comments paper to my amendment of this proposition. In it, he states, and I paraphrase, if the Deputy believes a legislative framework for pets in rental properties should be an excessive and costly way to solve this issue, he should vote against the proposition. And he is, of course, right. However, I recognise the many benefits, including mental health benefits of pets, particularly for people living by themselves. And so rather than vote against the general principle, I'm simply seeking a less onerous approach in the interests of all concerned. Politics of the possible using soft policy levers. In a recent article published in the JP, a commentator observed that most of the issues that the government of Jersey needs to deal with today do not need any legislation to be created. Rather, there is simply a need to sort the problem. So we're drowning in red tape. We need to stop this obsession with creating new laws where other alternatives are available. We struggle to build because there are so many legislative hurdles. It's a constant cry from small businesses and responsible landlords as they endeavour to make headway in a challenging marketplace. We have a responsibility to seek alternative solutions instead of constantly resorting to more law. We've recently seen the rented dwellings licensing regulations come into effect. When it was being proposed to this Assembly, I recall it was sold as light touch law, light touch, low cost regulation. I wonder how many landlords today would agree with that summary. We've got a housing minister itching to bring in a new legislation around a new residential tenancy law, when so much legislation is already in place and not enforced with a light and proportionate touch. Where does it end? Private landlords who currently supply 25% of the homes in this island are already walking away due to the increasing burden of red tape being placed upon them. That leads to greater demand for those properties that remain and will potentially push up rents. Homelessness is a very real consequence. In the comments to my amendment, I referenced the use of a policy framework. In 2023, the Government Engagement Framework was published. The framework focuses on the best practice policy development processes across government. But the principles apply to any project or proposal where the public's views are sought. There are 3 phases to policy development. It starts with the initial development of proposals, followed by policy implementation and subsequent evaluation. For example, when evaluating policy, it's important to engage with the public to understand how a policy will affect them. Too often, government jumps in straight in with legislation or spending money when other more economical and quicker solutions could be used instead. The policy framework document mentions policy levers, describing them as hard and soft depending upon the outcomes we require. Hard policy levers, such as legislation, cost more and take longer, whereas soft policy levers, such as producing guidance or public communications campaigns, are cheaper and quicker to enact and can be just as effective. The Minister even says in his comments that the practice of allowing pets exists as best practice across the rental market, where good landlords will happily allow their tenants to have pets, so long as it is appropriate in that particular property. Surely guidance will only serve to strengthen this practice without imposing restrictive new rules. I turn to the proposition and want to highlight to the Assembly the very real implications of committing this proposition to legislation. There is a real risk that requiring legislation to define the reasons for refusal will fail to address many situations where refusal would otherwise be justified and reasonable, but by dint of being absent in the legislation would render any refusal by a landlord an illegal act. The proposition seeks to grant all tenants occupying whatever tenure of property the right to keep and acquire a pet or pets. Would the eventual legislation include staff, service or tide, registered and unregistered lodgings? We don't know. The proposition, if adopted, poses the risk of a significant change to the agreed terms and conditions of an existing lease or tenancy agreement, freely entered into by a landlord and tenant, and which could be imposed upon a landlord at any time in the future with limited options to object. What is a reasonable reason to refuse consent? In the absence of a dispute resolution service, such as a tribunal or other binding mechanism for the resolution of a disagreement in the event of a refusal, this leaves both landlord and tenant without an alternative to legal proceedings. What an incredible waste of valuable judicial resources. There are so many more questions that need to be covered when it comes to legislation. Multiple pets in multiple occupancy buildings, defining what constitutes a pet, the number of pets, insurance cover. If we introduce a separate pet deposit scheme, how much should that be? I've been given examples of thousands of pounds worth of damage which doesn't remotely relate to the level of deposit taken. When it comes to the social housing providers, I recognise that they do have a policy of allowing pets in their properties, subject to safeguards regarding nuisance. What we must remember, though, is that these providers rent their properties on an unfurnished basis, whereas the vast majority of private sector rentals are on a semi-furnished basis, in that soft flooring is almost always provided. Whilst professional deep cleaning can work, even moderate exposure to animal fouling will result in soft flooring and in many cases underlay being so contaminated that replacement is necessary. So the point I'm trying to make is that legislation brings with it an incredible burden of legal responsibility, of which I've only just scratched the surface. Furthermore, the unamended proposition seems to try to address problems relating to a statistically insignificant number of tenancies, claiming that only 17 pets per year are being affected due to the landlord specifically not allowing pets. This appears to be the only number attributable to landlord intervention, and there is no data about whether there were reasonable reasons behind these. It would seem to indicate that the problem is managed sufficiently well already. The report accompanying the proposition is not sufficiently refined as to provide sufficient information or guidance on how the industry should react to the changes proposed, and it could be argued that the rights and responsibilities of landlords to manage is being altered without proper checks and balances being put in place. Arguably, the issue of animal welfare in terms of suitability of accommodation should be the most important factor, but seems to have been overlooked simply in favour of granting the default right to home pets. Proper consultation is required on such matters, but the Minister's comment paper reveals that this is an issue which has already been considered and which will only require a few extra lines in the already planned legislation to deliver it. So I wonder whether the Minister will put work on his new residential tenancy law on hold to consult with all relevant interest groups on this matter. Whilst no compelling argument for this legislation has been made, if the principle of the proposition is to be progressed, then adopting a more structured approach would seem much more appropriate. Hence my amendment to the proposition requesting guidance rather than legislation, which in turn could lead to approved guidance. For example, the Code of Practice produced by the Health and Safety Inspectorate is already seen as very valuable for the construction industry and work environment. This approach may well result in better outcomes for landlords, tenants, neighbours and pets. In his comments paper, the Housing Minister indicates that much of the work for legislation for a right to keep a pet has already been prepared. Turning that to a guidance document using soft policy levers should then be a simple matter and not take up further valuable law drafting resources. In conclusion, I'd like to finish with a point I made earlier. Most of the issues that the Government of Jersey needs to deal with today do not need any legislation to be created, and here I believe is a case in point. Using the very straightforward analytical approach as proposed in the Government Engagement Framework document simply confirms that legislation is an inappropriate response to the issues raised in this proposition at this time. I urge, therefore, members to support my amendment to the proposition. Thank you.
Right, Deputy, is the amendment seconded?
Yes, sir.
Deputy Mitek.
Thank you, sir. With respect to the issue of pets in rental homes, the States Assembly has three options before it today, which can be summed up as number one, do nothing, number two, do something, or number three, do something that gives the appearance of doing something, but is actually doing nothing. This amendment asks for us to do the latter, rather than allow a straight debate between the two tangible options. And while the proposer may purport this to be a compromise position, it is actually an inefficient surrogate for the do-nothing option. It asks me to expend time and energy on something that will have no legal effect and will, in all likelihood, be ignored by those who ought to pay the most attention to it. Guidance that is non-binding will provide neither tenants nor landlords with tangible rights or responsibilities and provide no framework for resolving disputes. Only legislation can provide these. And I'm currently in legislation mode. I'm producing a new residential tenancy law, which is my top mission this year, and we are well on track to delivering a draft law soon, after many missed deadlines in this journey. And I stand ready to add the issue of pets in rental properties into the mix if members want me to. And I will leave it alone if they don't. Incorporating it into the work we are already doing will be extremely easy because it's already been considered. It was part of Deputy Waugh's consultation on this last year, and the Renters' Rights Bill in the UK shows a good example of how it can be framed. To produce guidance instead of legislation will have to be a separate project. For the residential tenancy law, we are planning a publicity campaign and guidance that will accompany it. But guidance on an issue that won't be included in that law will have to be provided as standalone, because if it was included in that wider project, it would give a misleading impression that it was a matter covered by the legislation, when in fact it would not be. And I do not want to cause confusion on this kind of thing, or leave people with a false impression that they have rights and responsibilities that in fact they don't have, when the rest of that project will be focused on rights and responsibilities that will have legal effect. So there will have to be a demarcation between these projects, and my officers will have to produce a different product. And whatever form that guidance takes, perhaps a glossy leaflet, it will have to have a disclaimer on it which says something along the lines of, and by the way, none of this is binding, so you can ignore it at your will if that's what you choose, because that is what this amendment would deliver. But at its worst, theoretically, the non-binding guidance could actually be harmful. The guidance will say what landlords should do and also what tenants should do, but nothing would be stopping either party from cherry-picking from that to find the most convenient combination for them, or in fact choosing to take all of the proposals for one side of the arrangement and none from the other side. The guidance could theoretically serve as a blueprint for being unnecessarily harsh. So the cleanest way to resolve this issue is to reject the amendment and tell me what your appetite is for something more meaningful to be done on this. And if there is no appetite to address this in legislation, that is absolutely fine. I'll keep my focus on the other matters in the residential tenancy law that I'm keen to pursue. But if members do have an appetite for it, I'll come back to the Assembly when we debate that residential tenancy law with some extra articles in it that would provide the framework of rights and responsibilities for landlords and tenants, that clarifies that tenants will have the right to ask permission to have a pet, and that landlords should have reasonable grounds for refusing this request. That legislation will provide for these reasonable grounds that landlords may invoke if they do not wish for their tenant to host a pet in their property. It will not be an absolute right for every tenant to have whatever pet they like in their property when that's not appropriate or when the landlord has decent grounds for saying no to it. And so I can confirm that my intention would be to include every single one of the things that the Jersey Landlords Association has put in their letter to us, which we received yesterday, in that legislation. What they've proposed in there is absolutely right. We were already looking at that, and I agree with it wholeheartedly. That will feature every single one part of that. And if there are any issues at all with what I come up with, it will all be subject to another vote next year when the legislation is brought, and there will be an opportunity to scrutinise it, to amend it, or even reject it if I don't do a good enough job with it. So today is not actually about giving me a blank cheque on this. And I've said that I will commit to making sure that if P70 unamended is adopted, that when I bring forward a residential tenancy law, I will provide for an individual vote to be taken on those articles so members can express a final verdict on it at that point. But sir, I would ask members, please don't ask me to occupy my time with something that will produce no tangible benefits whatsoever. Let's stick to the actual debate and give me your steer on whether you want me to do it properly or to leave it for now, and I'll respect that steer either way. And so I ask members to reject the proposition. Thank you, sir.
Deputy Ayer.
Thank you, sir. I must say that I'm very concerned about bringing forward more unnecessary legislation which will directly affect every landlord in the island. It seems that the proposer of the proposition believes this to be a simple implementation process, but the consequences of such an action will lead to multiple cases of legal action, which only our learned friends will profit from. Members, I am sure, will have read the correspondence from the Jersey Landlord Association, which lists a number of serious concerns, the first of which is pet-related damage to property. This can include, it states, urine staining of carpets, underlay and floorboards, claw and bite damage to doors, windows and furniture, and pet hair and smells, which are very difficult to remove. This problem was highlighted recently. Only last week there was a court case in central London which revolved around the renting of a property in Notting Hill for the not inconsiderable sum of £5,000 a week. And we worry about the expense of renting in Jersey. When the landlord sought £10,000 in compensation for claiming that the tenant had failed to prevent her cat from urinating on the furniture and carpets. I believe that this sort of event will become commonplace in Jersey if we endorse the proposition unamended today. The Jersey Landlord Association also highlighted concerns of allergies for tenants, where it mentioned that certain pets make it difficult for future tenants to live in a property, or for the landlord to make the property totally clear of all animal hair. I am aware that cat allergies can be quite debilitating, and I also know that the proposer of the proposition has taken a keen interest in food allergies and shown great concern for that particular group of individuals who suffer severe reactions. But in this instance, she seems to be trying to regulate to allow that those who have cat allergies are not given similar protection and may well endure an allergic reaction because of a previous tenant's cat. Or she presumes that the burden of responsibility will lie with the landlord to fund a deep clean of all properties where cats have been permitted to reside under law. The proposer in a report suggests that we should introduce an additional pet deposit for new tenants, which must lead to the question, who would be able to afford such an additional cost? And also, would we therefore need a pet deposit scheme to oversee this? And of course, who would administer it and how would it be funded? We also have to consider whether there is actually a problem to be resolved in the first instance. Do we have any data available that shows tenants are being denied the possibility of keeping animals in their rented properties? And if so, what were the reasons for their refusal? I personally have not heard of such a scenario presenting itself, but without any evidence to support the conjecture, I do not believe that members should make any rash decisions. And finally, I am unsure of what the definition of pet or pets actually is. For example, sir, if I had a pet pig named Rasher, would I be permitted under the law to keep Rasher in my rented accommodation? And on that topic, sir, I would ask if the Attorney General can define to the Assembly what a pet or pets are under the law and whether such a classification has been incorporated in any other legislation. Thank you, sir.
Does it matter what the pig's name is for the purposes of the Attorney General's advice?
Absolutely not, sir. So, may I make a declaration of interest? The earlier member who made a declaration should make a declaration, and I am a landlord, I could say that I've got a cat allergy and a horse allergy, but I don't know whether it excludes me, but I have.
Mr. Attorney, I think you have been asked a question about the definition of pets in statutes.
Well, I'm tempted to refer to Siberian hamsters, but perhaps I shouldn't. The legislation would face a basic choice between attempting to define a pet or leaving the language as it is, of just generic language of a pet, and that would, in the event of any dispute, leave it for the court to determine whether the creature in question was a domestic pet or some other form of animal species. In terms of whether there is legislation where a pet has been defined, sir, I would suspect that somewhere in the vast bodies of legislation throughout the world, I'm sure that has been attempted, but I'm not sure that I could be specific today as to when and how that has been done, or where and how that has been done. And I'm sorry if I can't give more specific guidance to the questioner. Thank you, sir.
Deputy Barbara Ward.
Thank you, sir. The proposition pets in rental properties was raised and discussed at our recent St Clement parish surgery. The parishioners that attended unanimously agreed that this should be managed and agreed between the landlord and the tenant via, for example, amending the individual leases and especially around any cost incurred for repairs or any deep cleaning that may be required for at the cessation of the lease. It was felt that this approach would maintain reasonable and beneficial good relationships between the landlord and the tenant, and that both parties knew exactly where they stood. The parishioners also stated their objection to use legislation due to the number of excessive and costly variables, as we've just heard, and felt that this was not the way to address this issue at this time. The parishioners were also very concerned at the short length of time. The original proposition proposed by Deputy Catherine Curtis was expected to be brought in by April 25. They wanted to know, why's the rush? Anyway, so just to finish, I just want to say that I want to support our parishioners' views and to state that I will be supporting the amendment introduced by Deputy Ward. Thank you very much, sir.
Conor Harbison Mary.
Thank you, sir. Whilst we're now just debating the amendment, I shall address both that and the main proposition, if I may, and speak only once. Thank you. First of all, to outline my own credentials, as it were, I was an accidental landlord some 40 years ago, or became one. And whilst I've been fortunate in having tenants who've stayed with us for several years at a time, I have, during that period, nevertheless entered into a number of agreements. And except in one case, I have welcomed the idea that they have pets, and they have kept pets. And I do, in fact, actually prefer prospective tenants to have pets, and I say so for two reasons. First, as Deputy Curtis said, or indicated, I'm one of those fortunate enough to have been brought up with a family of cats and dogs from an early age, and I like to think I benefited from that, and I wish everyone else to benefit if they wish. Secondly, and perhaps not so altruistically, I find owners of pets tend to have a caring and responsible disposition. And I like to think that if they were tenants, they would address those same qualities to maintenance of the property itself. So, I am firmly in support of the principle that pets should be allowed where possible, and I would do everything to encourage whatever it takes to encourage landlords to say that. That said, my acceptance of pets has been a definite one on each occasion. The standard lease I entered into, and that I think is standard throughout tenants' agreements, is the tenant shall not keep a pet, or maybe an animal, dog or bird, to answer the question of what is a pet, or maybe a reptile too, without the written consent of the landlord. And I believe that is important. The landlord has a responsibility other than to just the tenant. He has to have in mind other neighbours, some of whom might be tenants or not, take into account barking dogs and the like, and maybe all manner of reasons. And I think that it will or could lead to, a restriction could lead to some landlords withdrawing from the market or adding to the reasons why they might wish to do so. So for that reason, I believe that the present situation i.e. written consent to be required, should stay. There's been little reference to the UK bill called the Renters Reform Bill. And it is the case that within that bill, which I believe is not due to go into law for another 2 years or so, there is a clause which reads, it is an implied term of every assured tenancy to which this section applies that a tenant may keep a pet in the dwelling if the tenant asks to do so in accordance with this section and the landlord consents. And it goes on, such consent is not to be unreasonably refused by the landlord. And there then follows a list of provisions culminating in the one as to what happens should that condition not be complied with. And it concludes, in proceedings in which a tenant alleges that the landlord is in breach of the implied terms, the court may order specific performance of the obligation. So what I'm pinpointing, sir, is the fact that in those detailed regulations, there is built into the equation, as it were, the need for details culminating court proceedings, and that is not what we need here, surely, sir. At the moment, the situation is relatively simple, and whilst I hope that landlords on the whole will agree, it is not a matter which we need to waste court time on. But to go back to the my other points, it is that the Housing Minister has helpfully explained that, yes, there is to be a new residential letting law, and in fact, the scrutiny panel eagerly await its production, and we have booked out time to receive it. And I make the point, sir, that as that is on track, I do question why there's need to bring this particular proposition at all. It will be addressed in that within that law. It will go to scrutiny, and in that connection, I think it's worth reminding members that when a similar exercise was conducted by scrutiny in relation to the licensing regulations, the panel put forward 11 amendments, 9 of which were accepted by the Minister. And the point I'm seeking to make, sir, is scrutiny is there to help the process. It will go into more detail as to what the pros and cons of the argument are, and I suggest that is the place where it should be gone into more detail, and this really serves to muddy the waters rather than anything else. So on that basis, sir, I am inclined to urge members to reject both the proposition, I'll come on to the amendment slightly in a minute, sir, reject the main proposition, on the basis that if certain fears can be allayed, they can be addressed in the scrutiny process, which will be much more thorough than time has allowed on this occasion. And turning to the amendment itself, I find myself in the unusual position of agreeing with both Deputy War and Deputy Mezek, or alternatively disagreeing with both of them on various items. I accept Deputy Mezek's point that the guidance does not actually lead to clarity. The purpose of guidance surely is to support or better interpret legislation already in place, and rather than replace it. So on that basis, I am inclined to as palatable as it might seem initially, to reject that amendment as well. That said, Deputy Ward does raise a number of very good points about the introduction, which applies to the main proposition as well, the introduction of legislation, the amount of detail required, the court process, etc., and the possibility of landlords not being as willing to let us as they did previously. So on that note, sir, I will finish. I believe that whilst I have said I very much support the idea of animals being accommodated wherever possible, I believe it is an unnecessary step at this stage, and that the interests of clarity will be better served if we left it alone till the main draft comes through from the Housing Minister, when scrutiny will scrutinise it properly, seek views of the public, and we can have a better informed result. Thank you, sir.
Thank you very much, Conor Tubb. Deputy Captain Curtis.
Thank you, sir. I'm pleased to see that Deputy Wall recognises that discriminating against tenants with pets is a problem that needs attention. Deputy Wall supports guidance being put in place to allow for a code of practice to evolve. I have to say that while I appreciate his concern, it is at its best, this amendment is at its best rather pointless. Addressing the concerns raised in the short report of his amendment. Firstly, a shortage of statistical data. This sort of data is not collected in Jersey. But if we are not living in a bubble, in an ivory tower, we will know from talking to people that it's a problem. We will also know it's a problem from the data described by the GSPCA and the Cat Sanctuary. We will know from the posts every single week on social media of families desperately looking for a pet-friendly home to rent. There is even a Facebook page specifically for this problem called Pet Friendly Lettings Jersey with 6,500 followers. I mean, what more proof do we need? I had a very nice landlady come to my constituency meetings to discuss my proposition, and her way of doing things is to get to know her potential tenants and discuss with them the responsibilities she expects them to have around their pets. The potential tenant either agrees or disagrees, and then the landlady chooses the most suitable tenant. Agreed duties like carpet cleaning, keeping the garden mess-free, etc., can be included in the lease. The amendment of Deputy Walls raises concerns about changes made to existing leases or tenancy agreements. I think we all know that existing contracts are there not to be broken or changed. So this is not a valid concern. Deputy Wall raises the possibility of homelessness if this proposition to legislate against blanket bans on pets goes ahead, and that is scaremongering. In his speech, he also mentioned that tenants with pets would require carpets being replaced at the end of the tenancy, and I don't believe that is true. I know that my last few rentals with my cats and dog did not require new carpets, and I received back my full deposits, and I think this is normal practice. Deputy Wall's speech appeared to be based on the comments papers from the Housing Minister rather than the actual proposition, which is disappointing. Deputy Iyer mentioned his concerns around pet allergies. It is normal practice nowadays for tenants to pay for a professional end of tenancy clean, and no one is going to go into anaphylactic shock after moving into their new home because cats used to live there after a clean. A requirement for professional end of tenancy cleaning can be a part of the lease. Whether a pet can be defined is not a realistic argument against this proposition. Deputy Barbara Ward mentioned her discussions at her parish, but I wonder how many of her group were tenants. I will remind States members that the draft legislation will come back to the Assembly, and as the Constable of St Mary said, scrutiny would examine it too, that is, if the proposition is voted through. A primary duty of States members is to make legislation. To produce guidance on this matter instead of legislation is a poor and weak response. It will not be more expensive, and guidance will be insufficient. I urge members to be brave and to vote for what they believe in, whether that is to support the rights of half our households to live in their homes as they see fit, being able to keep their beloved pets, which requires legislation, or whether they wish to protect the right of a small number of landlords who support blanket bans. That will mean voting against this amendment and then voting either for or against the original proposition. Guidance will be insufficient, and therefore I will vote against this amendment.
Deputy Scott.
Thank you, sir. I'm just really going to speak to this amendment. I was planning, and still am planning to speak with respect to the main proposition, but I'd like the Assembly just to have a look at what this amendment is saying and consider whether they agree with me that this in itself is red tape. Definition of red tape, at least according to one definition I've seen, it's a needlessly time-consuming procedure. And when I looked and saw what the meaning and what this proposition's doing, I just thought this doesn't really make sense. It's asking us to request the Minister for Housing to bring forward before 31st March 2025 guidance to tenants and landlords so that any tenant of a rental property be permitted, that's nice, permitted to request, thanks, to keep or acquire a pet or pets unless the landlord of the property provides a reasonable reason for not permitting this. So there's an actual barrier to actually the permitting. And for the criteria determining these reasons to be defined within the relevant guidance. Now, as Deputy Barbara Ward has pointed out, a lease is a contract and a contract can be negotiated. So any landlord can give reasons for just saying no, and any tenant can simply ask for something and have a reasonable discussion. But this is almost, I'm sorry, I do regard it, and I don't like to use words that could be potentially regarded as disrespectful, but when Deputy Mazek used the word pointless, I found myself in agreement with this. I think that this is a smokescreen. It gets in the way of actually just debating on whether or not there should be support given to tenants in terms of this position of actually asking where it's reasonable that they should hold a pet and to give a reasonable kind of indemnification or whatever else it might be to actually occupy a property. And the speeches so far have actually somewhat gone into the territory of the main proposition. And I find them extraordinary. I'll come back to that because I think you could be talking about children. That's been changed. You could be talking about all manner of things that you could actually negotiate, and to be actually saying, we want government to give guidance to landlords for giving reasons to say no. I'm sorry, sir, I can't support this proposition for that reason. It doesn't make sense.
Deputy.
Thank you, sir. Dare I say, I'm not going to enter into the discussions about cats or dogs or whatever. It's a really difficult issue. Frankly, and this is not, I don't wish to be in any way disrespectful, but the elephant in the room, if there was one, in relation to the housing, it's an analogy that works, sir. The actual elephant in the room in relation to people's ability to rent properties is an absence of supply. And it's all very well for this Assembly to take up time dealing with rules and regulations, but the market isn't working. The Housing Minister, who is advancing this amendment, I will be supporting Deputy Ward. I think it's the best balanced solution, it seems to me, but it's very difficult when we're having a debate about pets. If there would be enough, we've got the Housing Minister a month ago that said he wants the social rental market to be smaller than the private sector rental market. Well, if it's the opposite, he wants the private sector market, the rental market to be smaller than the social rental market. So we're crowding out private landlords, putting more and more red tape, putting a tax on them. Well, that's gone well. It is absolute nonsense, and people may they may tweet or they may titter at a elephant in the room. But the facts is the truth is there is a crisis in Jersey's housing market. There is huge unfairnesses in terms of the rentals that people are being asked to pay because there is a failure and a continued failure by this Assembly and previous ones to deliver on supply. The same is true in the United Kingdom, and I'm afraid fiddling while Rome is burns and not talking about the real issue is a real issue. And I'm so sorry that actually we have to debate these issues, because if the market was working, we wouldn't be here. And I prefer actually talking about supply side of how to actually deal with the real issue, sir, not this.
Deputy Coles.
Thank you, sir. First of all, I'd like to congratulate Deputy War for coming up with something new. We've heard of the carrot, we've heard of the stick. Deputy War has invented the feather in an approach to tackling red tape and regulations. Something that's light and gentle, looks good, but really doesn't do much, unless you want to come off your perch. So, as Deputy Scott says, this proposition really doesn't achieve anything. It doesn't do anything. By issuing guidance with nothing behind it, we are really doing nothing. This is just a little bit of smoke and mirrors to allow people some sort of comfort to say that we've seen a soft solution in allowing people to keep pets, but actually it doesn't achieve anything. And what I would say to members is actually you need to, as I say, come off the fence, come off the perch, and actually nail your colours to the mast in the second part of the proposition, of the main proposition. You can either support Deputy Curtis and bring in legislation that requires landlords to give a good reason why a pet should not be kept, or you don't, and you allow the status quo to continue. As Deputy O's have mentioned, there's negotiation within tenancies, and so people can negotiate whether a pet exists or not, but sometimes we need better guidance on these things, and unfortunately guidance is only strong when it has some sort of backing to it. Otherwise it can just be simply dismissed and achieves nothing. So, sir, I believe Deputy Ward's amendment to this main proposition is nothing more than additional red tape, a waste of resources, and also a waste of paper.
Comment St. Peter.
Thank you, sir. As constable and privately, I've seen both sides of allowing pets in a tenanted property. As constable, we have over 65 accommodation. I have to say the lease does actually say that there are no pets, but on a number of occasions I've come to an agreement with tenants moving in who've got an existing pet, or perhaps want a pet for company, and generally there have been no problems, and where there has been a little bit of damage, that's been rectified, and that has been an agreement between us and the tenant and worked very well. On the other side of it, I do have a property in the UK that's rented out to students mostly, and last year there were 3 students in the house. It's a 4-bedroom house, and one of the rooms was supposed to be locked. When I went to visit the property in the summer and opened the front door, I was greeted by a somewhat unpleasant smell, and it was quickly traced to the bedroom that should have been empty, where someone had been keeping a cat for the past year. Carpets removed, underlay removed. That had no effect. I got some professional cleaners in from Canterbury, and they had a go at it. But when I left the property 10 days later, there was still a smell from that room. I have to say, not necessarily only because of that experience, but also because I've seen it work in practice, I will be supporting Deputy Ward. Thank you.
To point of order, yes. I'm the only one that's declared an interest, and that was a speech. I completely agree with the constable, but surely we should be declaring conflicts of interest in a way that a matter which is before the Assembly, and I seek your guidance. I've declared an interest. It was late, I apologise, but other members who have an interest surely should declare it.
No. Generally, the declaration of interest relates primarily to a declaration of pecuniary interest. And I don't think there's a pecuniary interest at play here for 2 reasons. Namely, on its face, it's not a pecuniary matter, but also this is not the legislation. This is the in principle will legislation come forward which covers this particular area. Ultimately, though, I think it's a matter for members as to whether they think it's appropriate to declare an interest. There will be nothing wrong, as you have done, Deputy, with declaring an interest in your capacity as a landlord. And it may be appropriate for members to understand where other members are speaking from. But I don't think it's a matter of conflict of interest in the way that a pecuniary interest might very well be.
So I'm grateful. I just was quite confused. The Councillor was talking about the cost of clearing up cat litter, and I thought that was definitely financial, but maybe I'll take your guidance and sit down.
Well, I'm not sure that Councillor was declaring it as a personal pecuniary difficulty, possibly a parochial one, but I'm not sure. But,
Yeah, I thought that speech did actually sort of confirm that, you know, I was a landlord.
Right.
In the UK, not in Jersey.
The Deputy Gardener.
Thank you, sir. Follow the declarations. My husband is a landlord, and in the contract, I think that he has that if tenants would like to have a pet, they need to engage, and tenants did engage, and his tenants do have a dog. So this is where declaration finished. Another declaration, personal, I grew up with pets, 5 different pets, they changed, but we'll not go into the pets way that my parents think. It's not about the pets. Why I asked to speak, it's actually follow Deputy Bezic and Deputy Cole's speeches. I cannot see the situation, for me, situation in this life, never black and white. It's never two solutions. There are always options how we can progress. I cannot understand why we need to go from 0, having nothing, to 100, have a hard legislation. Have we tried something different? Have we tried to give the guidance? Does any landlord receive a guidance from the government saying what landlord is expected to do? We are talking about prioritization, budget restrictions. We don't have funds to develop hate legislation to bring forward, modern legislation to bring forward that we discussed today. We don't have enough money to develop very important legislations. And we didn't try to give guidance. So maybe as a first step, we just give a guidance and see if it will work. If it doesn't work, we can move to legislation. But why to go from 0 to 100 at the same time? So this is why I would be supporting the amendment.
Does any other member wish to speak on the amendment? Deputy Luce.
Thank you, sir, and I'll be brief. I'd like to declare that I am a landlord. I'm also a landlord who, some years ago now, had a property that leased out, a property that had been completely redecorated. 6 months later, the tenant left after keeping a pet there unauthorised, and the property needed to be completely redecorated again. When I read this proposition, sir, the one word I worried about, and others have expressed the same opinion, was the word pet and the lack of a definition. But members, fear not, because when the Attorney General was speaking just previously, I just went to the Oxford Dictionary to look at pet, and it says this: a domestic or tamed animal kept for companionship or pleasure. And the example they give, the pony was a family pet. I rest my case, sir.
Deputy Miller.
Thank you, sir. Sir, I would just like to start by questioning the assumption that has proceeded throughout this whole debate so far, that homeowners are free to keep pets. I'm aware of at least two residential flatted developments. One is for the older community, where people buy those flats in St Clement, and where the rules of the housing association, or I'm sorry, my law fails me, I can't remember the name of the structures, but the residence rules state very clearly that you may, if you have a pet when you buy, you may keep it, but you may not replace that pet or acquire one after you move in. There are other flats in the island where the rules in the article say that flat owners may not keep pets. So to have a blanket assumption that if you own your own property, you therefore can have whatever pet you want is I think, misplaced. And it would do no harm to do some research on that. And if we're going to make landlords allow pets, then surely we must consider whether people having bought their own property should also be allowed to have pets. The other question that occurs to me, sir, is whether all of the members here who are so keen to allow landlords to require landlords to have pets, I'd be quite interested to see a show of hands how many of them would also like to see dogs on beaches. Because many people do not want dogs on beaches. I do. I am a pet owner. I would love to walk my dog on a beach at any time, on or off a lead. And many of the people who are promoting dogs in rented properties, I suspect, would not agree to the prospect of a dog running wild or free on a beach. As regards the question of guidance, many of our regulatory systems in the island rely on a combination of law, codes of practice and guidance. It works very well in financial services and people do understand what they must require. It is very clear, and to suggest that guidance is completely irrelevant feels incorrect and slightly heavy-handed. I also just have to reflect that our CSP included reducing red tape and bureaucracy. I don't see that legislation is any less red tape and bureaucracy than guidance, or that guidance is any less or more burdensome to either government or landlords than legislation. So I think I'm inclined to support the amendment, sir. Thank you.
Deputy Alex Curtis.
Thank you, sir. Really, I stood up to equally declare an interest as a landlord. Again, I do agree with Deputy O's. If it is reasonable for us to declare this, even if it's not a direct pecuniary interest, it is an impact on those who do, either positive or negative. And I would secondly just touch on what Deputy Miller commented about the restrictions on properties. And on the topic of guidance, an application that came to the Planning Committee recently for development had a density of over 150 dwellings per hectare. And the reason I say that is under extant guidance by the department and the minister, dwellings must come with a residential management plan. The submitted residential management plan for this development had over 31 conditions that were applied, including no keeping of pets. I say this because clearly context is important in these cases, and ponies versus cats and dogs, to Deputy Luce's point, is very relevant. But I also ask in this sense, maybe there's a chance for guidance actually with regards to those who are looking to buy property in new developments. We are seeing schemes come forward that equally propose fairly blanket bans on pets, which may even enter the private market for all ages. So I would look to the Minister for the Environment to consider what guidance needs to be included within those residential management plans for new developments of what's considered very high density. And I will leave it there, sir.
Deputy Ferry.
Thank you, sir. Yeah, not too long ago, it was admissible to advertise properties with the caveat, no children. And thankfully, we as a society have moved on from that position. And it took legislation to do that, correct. However, pets are a different kettle of fish. And there are lots of reasons why pets may not be suitable for certain properties and indeed certain close-knit neighbourhoods. So equally, I recognise that pets can be really good for people's mental health and well-being, and generally a happy tenant is going to stay in that property for longer, which is generally a good thing for a landlord. But I believe that adopting the amendment to P70 would be a gentler way to change hearts and minds on this subject. And if it transpires in a year or two that the guidance is ineffective, then a proposition could be brought back to the Assembly, and if at that time it is successful, the guidance which has already been formulated, if this proposition is successful, can inform that legislative change. Also, if legislation is brought forward, guidance will have to form part of that process anyway. So either way, guidance is going to have to be put in place. Andium already have a policy position on this matter, and so formulating guidance based upon that policy should not be too onerous a task for officers. So I'm going to support this proposition because I think it's a good way forward. Thank you, sir.
Deputy Morell.
May come as no surprise, sir, but I've got nothing useful to say. I just wanted to declare that I am a landlord as well. That was all, sir.
Does any other member wish to speak on the amendment? Deputy Andrews.
Thank you very much, sir. Firstly, I must commend Deputy Catherine Curtis for bringing something forward that she believes in. I might not necessarily agree with what she is bringing forward. However, I think it's very important that we do discuss these matters. Now, for somebody like myself, I am a bit concerned about the prospect of legislation potentially being brought forward today. I do think there is room for guidance initially to be brought forward, and that is due to a few concerns that have been brought to my attention. For instance, rabbits living on balconies in social housing. I don't really believe that is an appropriate thing to do. And so I think there is a need for guidance to be brought forward to safeguard animals and their welfare, because I think that is quite important. But there is a broader issue, I think, if you are looking at legislation, for instance. Because some animals are really not appropriate for certain units of accommodation. Now, with myself, I live in Andium Homes, and where I live, there are several dogs who bark continually. And due to this being a regular occurrence, of course, there are neighbours who are often coming up to me saying, look, we've got an issue, there's a noise disturbance, and the children cannot get to sleep. And that was one real-life example that was brought to my attention. And due to there not being a reason to say it's not about evicting the tenant, but to remove the animal, it's a long-standing issue, unless if there's a number of complaints, and formally Andium might take action. But if you're looking at it from, say, the landlord's perspective, if you have entered into a contract with a tenant, and then all of a sudden you've got a tenant who's living next door, and you've also agreed with them that they can have a dog, and the dog's barking, and you've got a night shift worker trying to get their head down to get some sleep during the day, and they can't because there's a dog who is barking, then really the tenant would be within their right to go to the landlord and say, well, I'm sorry, but I am really getting fed up of this noise due to the dog that is next door. And so if you're looking at it from the perspective of the dog obviously has to remain in the property, if that's the basis of where we're looking at it from the perspective of this proposition, then it's going to create more problems than it is going to solve. And so I think the landlord has to use discretion at the beginning, and if they believe that an individual who's maybe got a number of pets is not suitable, then I think it is only wise that they turn down the tenant. And this is going to cause potentially another issue when we're looking at, say, parents who've got young children, but they've also got pets. And if the pets are the issue, and that's the reason why the landlord is turning them down, then there could be all sorts of legal complexities, because the household could quite rightly say, well, I'm sorry, but we've got children and you are turning us down. And so it could, again, create several problems, and of course through our judiciary there would probably be more demand potentially for their services due to elements of discrimination within our legislation. And so you do have to bear in mind that the landlord has a responsibility to ensure that the property that their tenants live in is habitable, and also there is no noise disturbance. And if you're looking at it from a landlord who has, say, an apartment block, and they have, say, 4 units, you need to make sure that everybody is able to live in peace. But I am certainly aware on several occasions where tenants are not living in peace due to the fact that their neighbours have pets, who again can be quite disruptive and noisy. It is only, I think, once that I have been aware of an animal being turned down when their owners separated, and there was 2 dogs, and they mutually decided that they would take a dog each. But for one of the owners, when they were moving into a property with their new partner, the landlord said no. And I happen to understand the reasons why, because the dog was a toy dog. It was probably under 7 kg, and it was yapping all the time. And so my friend who took on the dog, and they took on the dog because their partner had no choice but to take on the dog, because they had a friend who mutually stepped in. They were immobile, and they looked after the dog for about 4 days, and they had to say, look, I'm sorry, but it's not appropriate for the dog to remain here. So my friend had no choice but to take it on. But even when I spoke to my friend since the publication of this proposition, and I asked them for their views, they said to me, well, Max, where you live, my dog would not be ideal, because it would bark. And they have their own property. They've got a mortgage. And they were saying to me, every single time people come past a property, the dog would bark, and it was loud. And so if this was in social housing, or if it was in, say, the private sector, you can imagine there would be many people who'd be raising grievances. And who would they go to? They would go to the landlord. And so that would create a problem for the landlord, especially so when, for instance, you've got children in the property as well. It adds another layer of complexity. And even in my case, I've recently got myself a Glen-of-a-Mull Terrier. There's about 3,200 Glens in the world, so it's a very rare breed. And he is a very well-behaved dog. But when he was a puppy, and when he was very, very young, he caused quite a lot of damage. So my hallway carpet, for instance, he damaged that. My carpet in my lounge, again, it's damaged, plus my bed as well. So there's been hundreds of pounds worth of damage. Now, somebody like myself, I don't mind because it's my personal choice, and it's, you know, the property that I live in, and I'm entitled to have my dog because that's what the rules are. But if I was a landlord, I have to say I would not be happy if I came in to inspect the property, if the previous tenants had left, to find hundreds or potentially even thousands of pounds of worth of damage. And of course, that would be an expense that would have to be covered. Now, we also have to consider as well, with some private rental units, we do have people who are on income support who live in those units. So what happens if there is £3,000 or £4,000 worth of damage? How can somebody who is on a transfer payment of £250 a week have to then find, finances somewhere to then cover that liability? And so it will create a systemic issue, and the landlord would have to then chase the person to obviously put the payment forward to then cover the expenses. And so that would again create another issue. So as much as I do respect the fact that Deputy Catherine Curtis is truly doing something that she believes to be the right thing, I am very concerned about the proposal. And I do also feel that with the amendment, sir, it will provide clarity, I think, both for landlords and tenants to realise the expectations, to safeguard the animals and the animals' interests, but to also as well set out from the outset of any contract what the expectation is for all sorts of animals as well. So, for instance, as I mentioned earlier, sir, about a rabbit living on a balcony, I don't think that is right for the animal. And so I would put guidance in place to ensure that, for instance, if you are to get a rabbit, then it's probably best that you get an outdoor area if you are looking to find yourself a property. But there is another thing as well, sir, that I nearly forgot to mention. Even when I was on one of my walks probably about 3 months ago. My dog Samson was quite young then, and we encountered a young family at St Andrews Park. And the parents who I was speaking to, they said to me, and they were with their daughter, oh, we've got a dog at home. And when we got the dog, he caused so much damage to the wallpaper. Now, I don't know whether it was a property that they owned outright, if it was a property where they had a mortgage, or whether they were living in social or rented accommodation in the private sector. But again, that could be a very big cost, especially if you are a middle class or lower class family, and you know, you're two working parents, and all of a sudden you've got your animal who is you know, causing all sorts of destruction to the property. And of course, the landlord, quite rightly, will be saying, well, I'm sorry, this is not an expense to me, this is an expense to you. And I think it's quite important that if the tenant is to bring animals with them or to acquire them since the inception of their tenancy agreement, then it is for the tenant to cover that cost. Because the landlord, to be fair, and it's credit to the landlord that they have been accepting of the pets, and if the pets have proven to be disruptive, and if they have caused damage, then I think it is for the tenant to pay up. And even in my capacity as a tenant, I would be very happy to do that. If it was my responsibility that my dog, for instance, caused damage to the property, maybe damaging the skirting boards, then it is an expense that I ought to cover. It should not be the landlord who has to cover. So, sir, I think I'll probably just leave it there. Thank you.
Very much indeed. Does any other member wish to speak on the amendment? No other member wishes to speak on the amendment? Then I close the debate and call upon... Oh, sorry. There's a disembodied voice from the firmament.
Sorry, sir.
Was that Deputy Ward, was it? Yes.
Yeah.
Deputy Ward.
I'm sorry, sir, and I thank the Assembly for putting up with me not being there, but I was being cautious because I've got perhaps a few symptoms and there's a bit of COVID around, so I'm trying to be thoughtful of everyone else. So I've listened to the debate with interest, and I want to raise a few points before people vote on this supposed guidance. We have to remember, and the language is really important. So many people talk about properties. These are people's homes, and these are people's homes that people are renting at considerable cost. I know so many individuals, young people, who are paying 30, 40% of their income each month on the rent alone, plus leaving large deposits. And when they can't afford that deposit or they don't get it back in time, they're going to often the bank of mum and dad or to friends in order to take those deposits out. And there's a significant amount of money left there for exactly the type of issues that are being raised. Often, it's insisted that professional cleaning is undertaken at the cost of the tenant, the person living in that home. But it seems to me that a number of members are quite happy to say, well, we have a two-tier system here. If you're lucky enough to perhaps own your own home, as you know, I have a mortgage, lucky enough to have a mortgage, that's a strange phrase, but there we go. That's modern times. Then you can have a pet. You have that privilege of having a pet, and you can be allowed to own a dog or a cat or whatever. And then we have obviously the smoke string arguments about whether it's a dog or whatever, a horse or whatever. We're talking about people's lives here. And we're talking about people who perhaps want to have a pet to make them feel better, to have a companion, to have a friend that they go home to. And some people who live alone may well want to do that because it's good for their health. We have a rescue dog. He's the best thing that ever happened to us because I think he rescued us more than anything else. But I cannot think of what it would be like to have to give that pet up to move into rental accommodation. It would be a horrendous experience and not something I want to do. But I'm privileged enough to have a mortgage to be able to do that. I'm not a landlord. I am a pet owner. So I think we need to be very careful when we talk about just guidance, because underneath all of the debate here and all of the messages that are coming across are we can have guidance, but actually there are a huge number of problems and we don't really want to allow people to have pets. But we can produce some guidance and we can see off this proposition from Deputy Catherine Curtis by saying that we feel we've voted for something to do something, but actually, sir, ma'am, sorry, it will make no difference whatsoever. And we are therefore not making decisions. And it is interesting that some people who are talking about not wanting to take legislation are currently insisting on legislation regards fireworks. So sometimes legislation fits and sometimes legislation doesn't fit. That's a slight concern. So there are some huge benefits for having pets. Pet owners are often extremely responsible because they have someone else to look after. They have to organise their time. They have to organise their home. If you train your pet well, then it doesn't become a problem. And as for a damage to a home, the extremes that are being talked about could be extremes in any situation with any tenant or any person, in terms of illness, in terms of their responsibility, in terms of any behaviour within a home. If you rent out your home, that is always going to be a risk. I understand to some extent why deposits are taken, such large deposits are taken to protect that. But then also there is the opportunity to take out insurance if that is what is wanted. So we have a simple decision today. We either vote for guidance that will genuinely do nothing at all and just produce an extra piece of work for the minister, and leave the situation as is, with people being denied the rights to have a pet because they are unfortunately having to rent and don't have the same rights as everybody else. Or, as the minister has suggested, we vote against this amendment and vote on the main proposition itself and give the minister the opportunity to simply add this into the legislation, come up with something meaningful, come up with something that's controlled and has many more controls over the having of a pet than anything else, and actually make a genuine decision that may work into the future and give people the rights they need to live a life that they are paying through the nose for. Now, so I think we've seen a lot of extreme arguments here about the world falling in if people are meant to take pets in their homes. But, sir, I think we are talking about the well-being of people in our society and the well-being of animals as pets. And those two things together, sir, I think we should discuss properly rather than try and negate a meaningful proposition with a piece of guidance that, to me, sir, does nothing at all. So I urge members to reject the amendment and let's vote on the main proposition. Thank you, sir.
Thank you very much, Deputy. Does any other member wish to speak on the amendment? If another member wishes to speak, I close the debate and call upon Deputy Ward to respond.
Thank you, sir, and I thank all those members who've spoken and had what I think is an excellent debate. I'm not going to rehash all the arguments again. I'd just like to thank Deputy Catherine Curtis for bringing this proposition. It's a useful discussion point because it does matter to a lot of people, and I also would say that I recognise the many benefits, including mental health benefits of pets, particularly for people living by themselves. As Deputy Gardner has said, what we have to think about is this journey from some guidance through to legislation, and we have to start. Let's start that journey with guidance. I don't think it's a complete waste of time. I think it's important that we put things in place or give people ideas about what their responsibilities are. It's interesting, this differentiation between homes owned and there not being restrictions. Deputy Miller has highlighted that that's not the case. There are complexities around there. And also it's good to hear from Deputy Barbara Ward, who's talked about her constituents who are very concerned about legislation coming in. So in conclusion, sir, legislation is not necessary for allowing tenants to have pets in rental properties. With the correct guidance and policy framework, a code of practice could evolve that would be more beneficial to both tenants and landlords and provide less risk for straining of their relationship and contractual agreements. So I urge the members to vote for my amendment.
Do you call for the appel?
Call for the appel, that's me.
The appel is called for. I invite members to return to their seats. The vote is on the amendment to P.70. I'll ask the Secretary to open the voting and members to vote. If members have had the opportunity of casting their votes, Then I ask the Secretary to close the voting. The amendment has been adopted. 24 votes pour, 17 votes contre, no abstentions.
Could I have the pour and contras?
Those voting pour in the chamber, the Connotabs of St Helier, St Lawrence, Trinity, St Peter, St Martin, St John and St Saviour, deputies Luce, Morel, Lehegara, Ayer, Gardner, Osoph, Balash, War, Miles, Renouf, Miller, Ferry, Alex Curtis, Ward, Wilson and Andrews, and in the chat, sorry, Deputy Ward.
We now turn to, I beg your pardon, sorry.
Deputy Churn, sorry. Should have been.
Yeah, sorry, Mum, I did not vote for it. Sorry,
And
Mum.
those voting contre, Deputy Ward, and the Connotabs of St Clement, Grouville, St Mary, Southern, Labby, Doublé, Alves, Mezek, Coles, Porray, Scott, Catherine Curtis, Binet, Howell, Binet, Kovac.
Very well, we now return to the debate on the main proposition now as amended. Does anyone wish to speak on the main proposition? No member wishes to speak on the main proposition. I close the debate and call upon Deputy Curtis to respond.
Thank you, sir. I have a lovely dog, a rescue dog. I could talk at length about my dog, but don't worry, I'm not going to. My proposition is a result of many people coming to speak to me about their difficulty in finding a place to live because they have a pet. Some of the arguments raised in this debate have not been valid. For instance, if you stop and think for a moment about the suggestion that people can't move into a house if they're allergic to cats because cats lived there before, well, how often do you hear about this being a problem when people buy a house? It's really not a problem. I think Deputy Osoph, said it's a waste of time to debate this when there's a supply problem. But no, it's not. It's a matter which affects many people. Some States members have made light-hearted comments during the debate. I hope they're aware of those listening who've been badly affected by blanket bans on pets. Not taking this matter seriously is a slap in the face for many islanders. I'm sure it's not intentional, but it is showing a lack of respect for many islanders. By voting for the unamended proposition, you would have voted to end blanket bans. Landlords would still have been able to choose the tenant they think best suits their property. They would still have been able to refuse to have pets for valid reasons. There are tenants with pets who've damaged a property, but that does not mean it's okay to ban all tenants with pets. We don't ban all drivers because some are dangerous. We don't ban all alcohol because some misuse it. We should not think it's okay to discriminate against responsible pet owners because some are bad. Any States members who thinks this is not a problem for many islanders is living in their own little bubble. Guidance will not be sufficient to prevent blanket bans on pets, which is discriminatory against good tenants. It's very disappointing that the majority of States members could not support this legislation, but not surprising. However, guidance is better than nothing at all, and I ask States members to support the proposition.
Do you call for the appel, Deputy? No? Those in favour of it? You call for the appel. That is called for. I assume members have already in their seats. Ask the referee to open the voting. The vote is on P70 as amended. Members have had the opportunity of casting their vote. I ask the referee to close the voting. The proposition proposition has been adopted. 29 votes pour, 10 votes contre, 1 abstention.
Those voting contre, the connotables of St Clement, Grouville and St Mary, and deputies Labby, Luce, Lehegerer, Ayer, Rose Binet, Howell, Tom Binet, and the Deputy Scott abstained.
Very well, that ends the public business in respect of which a vote will be taken. The last item on the order paper is the in-committee debate relating to whether old age pension should be exempt from tax. I'm proposing to allow a half day for the debate. As members will know, it is one of those occasions where it is possible for members to speak on more than one occasion. Similarly, no vote is taken, not even an indicative vote. Therefore, it's a matter for members how it proceeds. I would suggest, although it also is a matter for members, that we will therefore adjourn this evening, start tomorrow morning, and deal with the half day of the debate at that point. However, before I turn the matter over to members, Chair of PPC, do you have anything you wish to add?
No, I'd just like to speak at the beginning of the debate, but I agree that we should probably start tomorrow. Thank you.
Very well. Do members agree that we will start tomorrow morning at 9:30 in the usual way, or do members wish to discuss that? Very well. There seems to be a relative unanimity in the sense of nem con, and accordingly the Assembly will stand.
May I just raise a point, sir?
Sorry?
May I raise a point in relation to the propositions that are being lodged today? I know that the GREF have been working very hard, as you have, sir, in approving various budget amendments. Yes. You don't notify the Assembly anymore, but they are lodged as a matter of course on the website, and they will be dated today, presumably.
I believe that's the case, yes.
Thank you, sir.
Yes,
Thank you, sir. And that's grateful thanks to all the staff that have been involved in it.
Behind the scenes, the GREF staff have been working enormously hard to get the various amendments lodged at the time. It looks like they're all over the line, so Deputy Scott.
So I just wonder, could I actually propose that we stay just to see the votes in favour and against, please?
Just to see what?
Well, you've proposed that we don't continue tonight, and I was just asking if I can put a proposition to continue.
You would like to propose before the Assembly that we do continue this evening? Very well. Is that seconded? Yes, sir. Very well. Well, then, does any member wish to speak on this? Otherwise, it might just be sensible to put it to the vote. I'm not going to risk a stand.
Call for the appel.
We'll call for the appel. Thank you very much. The vote is on should we continue this evening with the in-committee debate. Deputy Scott's proposition. I think the position must be that if the vote is adopted, we continue, and then we'll have to decide how long we continue for, because it's now 4:30. And if it is rejected, then we will stand adjourned and start at 9:30 tomorrow morning, stopping at 12:45 in the usual way, allowing a half day for the debate. So a vote pour is a vote to continue for some period yet to be determined. I ask the greffier to open the voting. Members have had the opportunity of casting their vote. I ask the greffier to close the voting. Sorry. The proposition is rejected. 17 votes pour, 22 votes contre, 1 abstention. Accordingly, the Assembly stands adjourned until 9:30 tomorrow morning.